Welcome, ladies and gentlemen. In the famous words of Yogi Berra, the manager of the New York Yankees, this may feel like deja vu all over again, but we're here for Mann and Patterson, the decision that was handed down by the High Court on the 9th of October of this year. Now, the High Court's obviously handed down another rather interesting decision today, but for construction lawyers, this was the big one, particularly with respect to the issues of quantum merit. We now have 3 judgments from the High Court dealing with the issues that were raised, and Derek Hand's going to go through the historical context of quantum merit leading up to the decisions that were delivered, and also canvass one of the plurality decisions, that of Justices Keifel, Bell and Keane. Lucas Shipway is then going to pick up the baton and deal with the single judgment of His Honour Justice Gageler, together with the judgment of the plurality of Justices Edelman, Nettle and Gordon. And as a result of the distillation of those 3 judgments, I'm sure we'll have an abundance of clarity and clear thinking in terms of how we approach the question of quantum merit in the context of a repudiation of a contract by an owner or a principal. So if you could join me to welcome Derek Hand to deal with the first part. Thank you very much.
Thanks, Frank. I know some of you were here for the first presentation we gave some weeks ago or months ago at this stage in respect of quantum merit and in the lead up to the anticipated decision from the High Court. So what I'm going to do is to take some time to recap on the development of the peculiar law of quantum merit in circumstances where a contractor terminates for a principal's repudiation, up to the point of the decision in the Victorian Civil and Administrative Tribunal that ended up in the High Court, and then I'm going to deal with the joint judgment, the first of the 3 judgments, as Frank mentioned a moment ago. But before I go to that, let's take a moment to remind ourselves of, well, what is a quantum merit? And a claim for quantum merit is a claim for the value of the work done and the services provided. When we last met, some months ago, the then state of the law was that when a contractor under a construction contract accepted a repudiation by the principal, the contractor was entitled to make a claim for quantum merit for the value of the work done up to that date of termination, instead of claiming for damages in contract. Now, when we gave that presentation some months ago, several several members of this chamber were appalled to discover that that was in fact the state of the law, and raised eyebrows to say that can't possibly be correct. But for those of us who practice law and construction law, we could say quite strongly that yes, that was in fact the case. Now, the availability of that remedy has traditionally been, in that circumstance, has been the subject of much criticism over the years. And in Keating on construction contracts, the authors observed that it could result in a substantial injustice if a contractor otherwise tied to an unfavourable contract were able to effectively get out of the contract and achieve a claim and restitution on terms that would be far more favourable than provided under the contract. That is, it was a way of getting out of an unfavourable contract. To trace the development of the jurisprudence, we go back to 1904 and a decision in the case of Lodder and Slowey before the Privy Council. This was a case from the New Zealand Court of Appeal, and the facts are these. There was a builder who'd contracted to construct a tunnel and some other works, and in the course of the works the principal excluded the contractor from the site and wouldn't allow them back on. So the contractor treated it as a repudiation, terminated, and brought a claim in quantum merit in an alternative to a claim in damages. And at first instance, the matter was heard before a jury, the matter went on appeal, and the New Zealand Court of Appeal held that the contractor was entitled to treat the contract as rescinded and to sue in a quantum merit for work done and work and labour done rather, and material supplied prior to the date of the rescission. The Privy Council agreed with the approach of the Court of Appeal. They said the respondent, that is the contractor, was entitled to treat the contract as repudiated and to sue on a quantum merit basis. Now, as I observed in the last seminar, the Privy Council's decision occupied fully 7.5 pages in the law reports, and the question of the availability of a claim in quantum merit, as I read the decision, was addressed in one single paragraph. So this decision forms in the future development of the availability, or the law on the availability of quantum merit, rather an important it features strongly. It's the subject of some criticism in the recent decision from the High Court, and I'll come to that in a moment. Let's jump forward by 30 years to MacDonald and Denny Lascelles, and in 1933, His Honour Justice Dixon in the High Court considered the common law position in Australia. And that was a case that again arose from the repudiation of a contract, in this case in the sale of land. His Honour Justice Dixon held that where a contract is terminated at common law by the acceptance of a repudiation, then the contract is not rescinded. Rather, both parties are discharged from further performance, and rights which have already been unconditionally acquired, or accrued rights, as at the date of termination, are not discharged, unless the contract provides otherwise. So that's a rather different formulation, and rather a different treatment to the Privy Council in Lauder and Slowey. If we jump forward then by another 60 years, and this time to 1992 in Renard Constructions, this was a case in the New South Wales Court of Appeal. There was a contract, construction contract. There was a schedule of rates, which was about $208,000. A dispute again arose, as between the contractor and the principal. The contractor treated the principal's conduct as repudiation, accepted, terminated, and brought a claim in quantum merit and was awarded $285,000. So rather a significant increase from the estimated schedule of rates. The principal appealed on questions of law to the Supreme Court, and Justice Cole decided that the arbitrator's award should be set aside. That then went on appeal to the Court of Appeal, where one of the issues was whether or not the quantum merit was capped by the amount of the contract, i.e. should it be the 208 rather than the 285. And the Court of Appeal held that there was no such cap or ceiling applicable. Justice Marr in the Court of Appeal stated the principle that where an innocent party accepts a repudiation, it has the option of suing for damages in contract or on a quantum merit. The law is clear enough, His Honour said, in that extract from the decision. On the question of the contract price operating as a cap on the amount that may be awarded, His Honour Justice Marr said that the contract amount may be evidence of the reasonableness of the remuneration, but certainly not conclusive evidence of that question. So it may have a role to play. On the question of whether a defaulting party be permitted to rely on the very contract that the prices in the contract that had repudiated, the court was fairly unambiguous, or His Honour was unambiguous. It would be extremely anomalous, he said, if the defaulting party, when sued on a quantum merit, could invoke the contract which he has repudiated in order to impose a ceiling on amounts otherwise recoverable. So it's not, would not operate as a ceiling, that is the contract price, as much as it could operate as would be evidence of the reasonableness of the remuneration. So if we jump ahead then to 2009, there's a Victorian Court of Appeal decision in Sopov and Kane Constructions. And in that case, again, a dispute between a contractor and a principal, at this time over a progress claim where the principal had deducted liquidated damages. The builder again treated the conduct as repudiation, terminated, and sued in quantum merit. The Court of Appeal noted in that decision, noted in dealing with the claim for quantum merit, that there was a growing chorus of criticism, judicial as well as academic, of the availability of quantum merit in circumstances of rescission, and observed that the decision in Lauder and Slough, and the cases that thereafter refer to it, were founded on this notion of the rescission fallacy. That is, the notion that the acceptance of a repudiation had the effect of rescinding the contract ab initio. It's fiction. They said that from the critics' perspective, it was an error of principle to permit recovery on a quantum merit. And the court observed that in their view, this was a very powerful criticism. But they observed that unconstrained by authority, they may well have held that the remedy was not available, but observed in this case that they were heavily constrained by authority. I should state that special leave had been refused in Renard. That was an earlier step in the reasoning. And ultimately held that the builder was entitled to recover the fair and reasonable value of the benefit conferred. I'm sorry, I've just jumped ahead there. Sorry, I've jumped ahead. That was the Court of Appeal. In fact, the slides and the notes that haven't matched up. That was the Court of Appeal dealing with the Madam Patterson, I beg your pardon, and referring back to the decision in Sopov. Something wrong has happened here. I'm sorry. I'm just going to jump through these slides with you. On appeal from NCAT, there was an argument advanced by the owners that the builder ought not be permitted to have quantum merit available as a remedy. The court found, the Court of Appeal in Victoria held that it was bound by the decision in Sopov. And then the matter comes before the High Court. And there were three grounds of appeal to the High Court. The first ground was that the Court of Appeal had erred in holding that the builder was entitled to sue on a quantum merit basis. The second ground was that, alternatively, if the builder was entitled to sue, then the Court of Appeal erred in finding that the price of the contract did not operate as a ceiling. And the third ground of appeal related to an aspect of the Victorian legislation. I'm not going to concern ourselves with that in this seminar. Those are the three grounds of appeal. There were three judgments. The judgment I'm going to address you on now was the first joint judgment of the Honours Justices Kiefel, Bell and Keane. And the joint judgment wastes no time at all in getting straight into the determination of the matter, and says that in paragraph 4 says that the issue of the first ground, that is whether or not the remedy should be available, should be determined in favour of the appellants. That is, that no, it should not be available. On that basis, it was unnecessary to address the second ground of appeal, and then on the Victorian legislation agreed with the later, the further joint judgment of the Honours Justices Nettle, Gordon and Edelman. Lucas will talk to you about those matters. Just bear with me a moment. The court cited with approval, their honours cited with approval, Dixon's statement of principle in Denny's Lascelles, which I referred to earlier, to the effect that accrued rights, as at the time of termination, remained enforceable. And although their honours felt that it was not necessary to answer or address the second ground of appeal, having determined the first ground in the way they did, they stated essentially that the terms of the contract must govern the amount of compensation payable by way of damages for loss of bargain. And I want to take you through a series of extracts from the decision. Even though the innocent party is no longer entitled to performance of the executory terms, those terms inform the quantum of damages recoverable, said their honours. They observed that a restitutionary claim, unconstrained by the bargain, would impermissibly cut across the parties' contract. So in other words, a claim in quantum merit would, in effect, be stepping around the bargain contracted as between the parties. They said that restitutionary claims must respect contractual regimes and the allocations of risk made under those regimes. And in circumstances where the contractor has enforceable contractual rights to money due and payable under the contract, there is no room for a right in the hands of the contractor to elect to claim between a reasonable remuneration, unconstrained by the contract between the parties, and an alternate claim in quantum merit. To allow a claim in those circumstances, the owner said, would be to subvert the contractual allocation of risk. So very, very strong focus on the primacy of the contractual dealings between the parties. And this is a constant theme that was through this joint judgment. To allow a restitutionary remedy of the type contemplated by the earlier decisions, the Honour said, would undermine the parties' bargain as to the allocation of risks and quantification of liabilities, and so undermine the abiding values of individual autonomy and freedom of contract. And on it goes. This is, again, a constant theme through this joint judgment. It will be inconsistent with the respect due to the contract made by the parties, whereby their commercial risks have been allocated between them and the liabilities limited. It would subvert the default remedial regime of contract law to which the parties by contracting have submitted. So you can see there that there's a very, very strong focus on contract as being the source of the remedy, not quantum merit. And notwithstanding that their honours chose not to determine and felt no need to determine the second ground of appeal, they have, however, made some very, very strong comments in respect of the significance of the primacy of the contractual regime. I've got no idea what that's doing. There we go. In response to the comments by His Honour Justice Maher in Renard, their honours in the joint judgment observed that really this sort of reasoning failed to acknowledge that it's precisely because the parties have agreed upon the contract price for the performance of work that it is to be regarded as the greatest possible remuneration for the work agreed to be performed. So there is commentary through the decision about the role of the contract price in terms of the assessment of a claim. Ultimately, they held that Lauder and Slowey should not be applied in Australia. And this observation from the joint judgment goes back to what was said in Keating, the concern raised in Keating about the capacity for a builder to effectively get out of an unfavourable contract. The Honour said that it may be that some builders actually set the prices at a level in expectation that they may well be able to get out of the contract later on. If that is the case, any such expectation is distinctly not to be encouraged. And honesty and efficiency in trade and commerce are not promoted by a rule that allows the recovery of a windfall. You can see there what the runners had to say. They concluded with this. They said that it may be that in some cases justice will not be done without a restitutionary claim, but in general terms there will be no need to have recourse to a remedy in restitution where a claim and contract is available, but did not go on to consider any other situation, with confining their comments to the scenario of a principal, I withdraw that, a contractor terminating for a principal's repudiation. The case did also deal with the submission made to the court about a total failure of consideration, but the court rejected, in this joint judgment, the runners rejected those submissions and said that to put the case, particularly where there have been severable obligations of payment, to put a case on the basis of a total failure of consideration was really just putting the rescission fallacy in a different guise. So that's the very clear message from the first joint judgment in Mann and Patterson, that the line of authority as expressed in Sopov is no longer applicable, and that the remedy of quantum merit would not be available to a contractor who terminates for a principal's repudiation. I'll hand over to Lucas now.
Thanks very much, Derek. And as Derek indicated, the first judgment that appears in the version of the case that's available at the moment, that is the judgment of Her Honour the Chief Justice and the other judges that joined with her, is quite trenchant in its rejection of the hitherto understood position. I'm going to talk about the other two judgments, and those judgments have a slightly different character. They agree with some of the outcome that the first judges reached, but they get there by a different way. And I think with a little more reasoning, if I can put it that way, with respect, the first judgment, as I say, trenchantly attacks the issues, but sometimes does so, it seems to me, from the point of view of looking at policy questions, and you've heard Derek speak about those, questions about what might be seen as commercially acceptable conduct, discouraging builders from seeking to get some better outcome, for example, rather than perhaps from the point of view of looking at where the authority has taken the law up to now. If I could then take you first to the judgment of His Honour Justice Gageler. Now, His Honour agreed with the first judgment in respect of the question of whether accrued rights were the answer to part of the claim. The case of Dennis Lascelles that Derek referred to dispelled the rescission fallacy and made it clear that where you have done a contract and accrued a right to payment under that contract, then that survives termination. And Justice Gageler applied that and said that where the work has been done up to a certain point and the builder has accrued an entitlement, that entitlement is the answer to payment for that part of the work. But His Honour drew a distinction between that part of the claim and the claim for work for which a contractual right to payment had not yet accrued. What you've got hopefully in front of you, if you haven't got it on your chair, there might be one near you, is a copy of a page of the judgment which I've printed out just because it's easier to see, I think, in hard copy. This is from the judgment of Justices Nettle and others, but you'll see there the critical clauses of the contract dealing with the stages of the work and payment for those stages. And you'll see there were, in this case, as is often the case with building projects, an agreement that there'd be payment by way of percentages. There's a deposit of 5% payable, presumably up front. Then there's a base stage, a frame stage, and so on. And you'll see that there's a final payment upon completion. The amounts paid at each stage differ, so that in the middle there's a stage called the lock-up stage, which usually, and I assume in this case, was where the house is taken to a point where you can lock it up. So there are doors and locks on the doors and windows and so on. And for that stage, to get it from frame to lock-up, the builder agreed that he would accept 35% of the total price. That's just an example, but you can see that there is a lumpy character to the payments. It's not just 10% times 10, for example. And I'm not sure, because it's not clear, I think, in the judgments where precisely the builder had got up to because of the way in which the case was run below. But what His Honour Justice Gagler is saying here is that, let's say the builder had got up to lock-up stage and had begun work on the fixing stage, which is the next stage after that. On his analysis, the builder would be entitled to be paid all of the instalments up to that point. So 35 plus 15 is 50 plus 10 is 60 plus 5%, 65%, with 35% still to come. And a proportion of the fixing stage payment would be due, but according to His Honour, that stage would be payable on a quantum meruit basis, because His Honour's analysis was that the parties had not agreed for an entitlement, an accrued entitlement for that work. What the parties had said was, your entitlement accrues once you complete each stage. And so if the builder is partway through a stage, there's no accrued entitlement, and on termination the parties are left to the law to work out what is due to the builder. That slide on the screen deals with the points I've made. I think the doctrinal basis for His Honour's view was that approach as to the accrued rights meant that the builder got what was agreed. He said it was consistent with MacDonald and Dennis Lascelles. In relation to the part where no right had accrued, His Honour agreed with the judgment of Nettle, Gordon and Edelman, which I'll come to, but he adopted a narrower path of reasoning, which I'll explain briefly. The stages of that reasoning were really as follows. If quantum meruit were not available, the builder would be left only with damages. That's the view that the first judges came to, that Derek spoke about. But according to Gagler, that wasn't consistent with authority. Dennis Lascelles and some cases by Chief Justice Jordan in the 1930s, after Dennis Lascelles, had clearly said that quantum meruit was the appropriate solution to that problem of non-accrued entitlements. Again, on a doctrinal basis, according to His Honour Justice Gagler, quantum meruit has to apply because the innocent party cannot accrue an entitlement to be paid under the contract for the work it's done where the contract has come to an end and no right has actually accrued under that contract, and yet the defaulting party has had the benefit of the work. So that seems to me to be a rational, if I may say so, approach to that problem, and to take account of the earlier authorities. I'm being a little bit cheeky in drawing attention to this passage, but I thought it was interesting. His Honour Justice Gagler has a unique style, and in this passage seems to me, and I could be entirely wrong, but I think he is making a comment about the much longer judgment of Justices Edelman and others, which follows in the report, and casting doubt about their attempt, I think, at trying to draw some of these threads together under what he calls a very big idea, and he uses initial capitals. So if we're seeing some humour in the judgments of the High Court, I think that's to be applauded, although, as I say, I'm not sure whether that is meant to be a slight or rather just an explanation of His Honour's approach. The next aspect of His Honour's decision, which is important, is that he decided that although quantum merit applied as to the unaccrued entitlement, nevertheless contract creeps back in because contract does act as a cap on that entitlement. Insofar as His Honour said that, he considered that Renard was wrongly decided, which is a reasonably dramatic development, I suppose. There's a question, obviously, as to how much use quantum merit is if the contract caps the entitlement. I suppose it means that quantum merit comes in and provides an answer to the question of quantum, but the builder will never do better than he or she would have done under the contract. The actual method by which apportionment is to be undertaken is not grappled with by His Honour. Rationale, again, he refers to the rationale that the first judgment referred to questions about incentives to terminate, and His Honour refers to the policy of the common law and says it demands that the problem of distorted contractual incentives be addressed. So that's the basis for his view that the cap should apply. In that context, having set Renard to one side, there really is no authority to help the judges on that, and I suppose on that basis it's fair for them to be drawing on policy bases. Turning then to the final joint judgment, that of Justices Nettle, Gordon and Edelman, they reached the same conclusions as Justice Gagler on the accrued rights issue. They said that where a contract fixes the price for services and is terminated for repudiation, the innocent party has an accrued right to payment. Now, in doing that, I mentioned that there was a little more reasoning in their judgments, and they grappled with, in a bit more detail, the concept of the entire contract. Of those of you who were here for our last presentation will have heard us speaking a little bit about that. It's an old concept, but it is fundamental in this area, and it refers to whether or not the contractual promise is a promise to do a singular body of work, as it were, in return for a singular payment, or rather a promise to do a series of stages of work in return for a series of instalment payments. Traditionally, building contracts were seen as entire contracts because they were in fact usually set up in the formal way. That is, someone promised to build someone else a house, and the owner promised to pay a price for the house, and the price was paid upon the completion of the job. But obviously, to assist builders with cash flow, the practice has developed where payment is made in the course of the project. Now, in most large infrastructure projects, there will be an express provision to the effect that the payments are made on account. And the expectation generally is, I think, that it is really still the classic arrangement. It's just that payments are being made to provide the builder with cash flow, and at the end of the project there will be a reckoning, so that if the builder has been over or underpaid, there can be an adjustment. And generally speaking, and there's some various references to this in the cases over the years, that has been treated as an entire contract. Now, this particular case wasn't a very good vehicle, arguably, because it was a small-time domestic building contract. It did not have the words "payments are on account," and you will have seen from the document I've handed out that there was, it seems, a provision for a series of instalment payments in respect of a series of stages. Now, the first judgment makes express reference to the fact that payments were made in stages, and Justices Nettle, Gordon and Edelman do the same. And they say that in this case, the obligation was divisible. It wasn't an entire agreement, but rather a divisible agreement to do work in stages. Why does this matter? Well, it matters because if it is an entire agreement and that entire agreement has been repudiated, the traditional view was that that is what entitles the builder to say, well, I haven't been paid for this job as a whole, and I've been prevented from completing the job as a whole, and so I'm entitled to quantum merit for the job as a whole. Where the work is seen as divisible, then the scope for the quantum merit shrinks down, and that's the approach that both Edelman and that Gagler and Nettlegordon and Edelman took to this issue. Their honours gave some guidance as to how to discern an entire contract from a divisible one. What's interesting here is, as I say, the evidence didn't enable the High Court to tell precisely how much work had been done and at what stage the work was at, so that ultimately it was remitted to VCAT for that to be worked out. And as I mentioned, there was no clause here to the effect that payments were on account. On the issue of whether the contract price acts as a cap, their honours took the same, or reached the same conclusion as Gagler. They again took a bit of a longer tour through the cases and placed considerable reliance on English authority and cases about allocation of risk. The essence of it seems to be that again, the doctrinal idea, I suppose, that the parties have agreed a particular price, that should be a price that governs the working out of a price, even though it's in a quantum merit context. What are the upshots for contract drafters and parties in dispute? I think that's really the most important thing that we should be thinking about. Obviously, the question of whether a contract is entire or not is critical. Now, as I said, this case is not a great vehicle because the court didn't grapple with the meaning, for example, of the words payments are on account. It may be that even where those words appear and they are alongside other obligations for payments to be made by instalments, that the contract will be treated as being divisible. We just don't know about that. I've extracted a passage from the joint judgment of Edelman and others in which there's a sort of bald statement that construction contracts divided in stages will be divisible, but there's a footnote, and the devil is always in the footnotes, to the effect that in each case it's a question of construction. That's why we're here, I suppose. The first judgment again touches on the point, and I think there is a clue in the reference to the lack of a clause about accounts, which points again in the direction I'm indicating. That is that if the parties have clearly stated that payments that are being made in the course of the work are really for cash flow only and are not intended to be payments in respect of an accrued right for work done up to the date of that payment, then it may still be an entire contract. And that's the question, I suppose, to be grappled with. Now, it depends who you're acting for as to whether you're interested in preserving a right to a QM or not. You might say that in the post-Mann and Patterson world, where the contract price acts as a cap, QM, the availability of QM is not such as big a deal as it was perhaps once. That then obviously leads into the question of how do you price the work if the contract is the cap, but you haven't got to the end of the job. It might be straightforward. You might say, well, I've got to this stage and the contract says that's the price for that stage. But the real world is usually not that straightforward. And so it may be that having regard to the new paradigm, we need to be very clear in saying how the price for the work that's done is worked out so that it can be applied in a termination context. Those are the points I wanted to highlight out of those judgments, and I think, as I say, out of the judgment, the case as a whole, Are there any questions for me or for Derek?
Perhaps I can ask Derek to join Lucas at the lectern, and I'll see if I can do a Tony Jones impersonation and moderate this. If there aren't any questions immediately, I certainly have one, and it comes on the point you raised there right at the end there, Lucas. Looking at the example you've given us,
Yeah.
Assuming that the termination, assuming these provisions were in fact on account, and the builder had reached lock-up stage and hadn't actually commenced the fixing stage, having regard to the fact that the references are to the contract as a cap, or at least, yes, quite almost conclusive evidence as to the entitlement to be received, even if it wasn't considered an entire contract, do you think that the recovery by way of a quantum merit would in effect be the total sum of the 65% by those particular figures?
That seems to be the upshot. That seems to be the upshot, because the judges aren't indicating that there's any leeway for that. I mean, you heard the point that Derek made, where there's a reference to, perhaps justice will indicate that some other solution should apply, but that doesn't help us terribly much. If the contract is a cap, and the work can be shown to have reached a particular stage for which a contractual amount is shown as due,
as part of their bargain,
whether
then
or not
it's on account or
that's
not.
right. Then yes, I think that's right. Now, perhaps the difference to that might be if somehow the contract delinks the payment from the work done. Now, that's usually not grappled with, but what I mean by that is, if payments in instalments are really for cash flow, then it may be that they're not being paid to compensate for the work done to that point specifically, rather they're being paid so as to keep the builder, if you like, liquid so that they can finish the job.
You're talking about a fairly common practice whereby builders load up the early part of their progress payments so that they can get the cash in and order materials, et cetera, for work that hasn't actually been done yet.
Well, exactly. So if you've bought materials and they're sitting in your yard, let alone on the site, I suppose, for this, well, that's right. Has the owner had the benefit of that work? Well, presumably not. I mean, and especially if there's a Ramalpa clause, for example, it means the material has to go back to the supplier.
That's right.
And so, but I think, and the judges don't grapple with that at all because, as I say, the evidence didn't really allow them
but
to.
on the traditional quantum merit, you would be looking at those sort of things. But on this arrangement, you say,
That's
well,
right.
you agree
That's
to
right.
pay them $50,000 up
That's right.
front.
And one of the reasons I gave everyone that printout was to show that that seems to be a straightforward way of setting up the contractual arrangement. It's digestible, you can see there's some logic to it, most of the payments are in the middle, there's a 5% deposit up front. The question arises, what's the 5% deposit for? I mean, is there really 5% of the total cost having been incurred prior to any work being done? Maybe, but you wouldn't expect the builder to have actually worked out that 5% of the total cost will keep me whole for what I've done up to that point. Right, really what's been done there is giving someone something that they can agree to, which gets the builder to where the builder wants to get at the end of the project. And I think that points up some of the limits of the sort of economic rationalism that you're seeing in the judgments, because the judgments seem to be saying the bargain is king because the bargain reflects what the parties expected, but that's not always quite right, it seems to me.
Well, even in the first judgment, they dealt with it as a sort of total failure consideration question. And I in fact had extracts from the slide, but I cut them out along with the other ones that I put out back.
Sorry, I think there's someone at the peanut gallery at the back wants to throw something at you.
Can I buy a comment?
Oh,
Can I just say that Ronnie Marr was too good a lawyer to determine restitution and renard on the basis that he thought termination operates ab initio. There are too many good lawyers that have actually had a stab at restitution, none of whom would have approached the issue of restitution on the basis that they thought termination operated ab initio. contrary to what the three said at the beginning of this judgment, all of those judges, all of those people, all knew that there's a difference between decision and termination. And when you read this judgment, it's like these guys are reading this law for the first time thinking, oh, is that how it works? The reason the cap existed, the reason that Roddy Marr decided that cap is because he was operating in an area where contracts for services have always been regarded as entire contracts. And a construction contract is a contract for service. There's too long authority to go contrary to that. The reason the cap was born is because once you recognise that a contract for service is an entire contract, then you have to have a regulation that deals with what happens if you're the guilty party breaching that contract. And so Roddy Marr said the cap operates because both sides are operating in a regime where you don't have anything else other than an entire contract, and the rights are based on restitution, and therefore you've got to have something to regulate why an innocent party can recover proper valuation and a guilty party cannot. That was the cap, and that's what Renard's about. Secondly, the first judgment fudges the issue. The reason it fudges the issue, and I've studied this, and I'm thinking, what are they actually saying?
Sorry, by the second judgment, you mean
The first judgment that Derek spoke about.
Right. How many points do we have, by the way?
2 points, this point. The first judgment fudged the issue. Stephen Gagler didn't create the circumstance where he actually had a discussion about what you do with work where the right had not accrued. It directly arose for consideration. That's why the 4 of the 7 judges dealt with it. The 3 that didn't deal with it are the ones that based the law on decision fallacy, and they had no answer for that. They in fact posed the question and said you should not recover, in essence, for that payment, which is wholly intellectually unsatisfactory. What do you think?
Take that as a comment.
Yes. Well, that's all very interesting at an intellectual level. I suppose the question is how do we deal with it as a practical matter in terms of the rights that have been allowed for by reference to the judgments that have been given. I suppose the question that I would have, perhaps take a different approach to it, is having regard to the fact we've got 3, 3 and 1, where do we land on all of this?
Yeah, I'm picking...
and in terms of the practicalities of articulating claims and those sorts of things.
I think picking up Franco's point, there is a majority of 4 to 3 to the effect that, as in respect of non-accrued rights, quantum meruit applies, is available. It seems that the same for applied a cap in that context. Contract price is a cap. First 3 judges don't really grapple with that, but that must be consistent with their view, I suppose. They certainly treat the contract as king. So we've got at least that much clarity. And as to the question of accrued rights, they all agree that stands post termination.
And to the extent that the rights aren't accrued, whether because payments are either on account or work has been done and the milestone hasn't been reached, there is a right to a quantum restitutionary quantum meruit, but that is governed by what the terms of the contract are for the purposes of valuation.
Yes.
And an entire contract stands in a completely different, on the face of it, a different category altogether.
But even if you do have an entire contract and the quantum meruit is available to you, if there are staged payments nominated either for cash flow purposes or anything else, does that govern what your recovery is depending on where you're at when the work when the contract gets terminated?
I answered that question very hastily before. What's your view about that, Derek?
I think it's left. I'm not sure.
Maybe that
I'm
answer.
just not sure.
Well, my reading of it, for what it's worth, add more opinions to the mix is that it is, and that really at the moment the thrust of the authority is
that it is available.
That even if you are seeking a restitutionary quantum meruit, is governed by what the terms of the agreement were for payment for that work. So the schedule of rates that you may have agreed applies, even if you're not entitled to get paid until the end of the day, even a regime for progress payments. It depends, I suppose, to the extent to which the progress payments are specific, because a lot of these claims are simply you can make a claim every month for whatever you've done, and we'll see how you go. And that's not going to inform you greatly in terms of where the contract is.
But the first joint judgment expressly disavowed having to deal with that second ground of appeal, but then it goes on to deal with the context of...
And did any of them enter into the wonderful world of the security of payment act?
No.
People getting paid for this sort of work under a statutory regime?
No.
No.
They decided to leave that sort of little rabbit hole for
It did
Alice
not.
and
I assume
others.
put the rise on
Sorry,
it.
yeah.
Yes.
No.
Yes, sorry. I was just wondering what substantive difference to the outcome there might really be between a claim in damages only on the one hand and a claim in quantum merit capped by the contract on the other. So to the extent, for example, that work's been done but there hasn't been enough approved right to get under the contract, wouldn't that come out in the wash of damages being assessed on the basis of putting the contractor in the position as if the contract had been performed?
It's not a bad point, actually. I mean, one of the things that was occurring to me is that why couldn't you sue for damages for breach of contract and say you prevented me from achieving this particular milestone, and my damages are the money that I would have been paid, part of it,
Yeah.
for the work that I'd done to that point, plus the profit that I would have earned on the balance of the works, and so that your ultimate claim for damages would in effect be the same. So that it would certainly be arguable, I think, as a matter of damages naturally flowing from the breach. You could say, well, you've prevented me from, because of your breach, I'm not able to proceed. If I had, I would have completed the works, I would have been paid under the contract to the extent that I'd done that work, and I would have got profit on the balance of the work that I didn't do.
But that's premised, isn't it, on the idea that the contractual rates are mobilised in the assessment of the quantum merit or the claim damages, whereas the early position was that it had no role to play. I think
That's the difference.
That's the practical difference.
So I think you're right insofar as in the new paradigm where the contract is the cap, then there's the difference probably vanishes generally, because if in the old paradigm if you underbid on the contract, then you couldn't prove damages because you weren't making a profit, and you didn't stand to make a profit on it. That's
Well,
right.
arguably, you could be worse off, because if you say reach midpoint of a contract, and you said, well, I want a restitution in quantum merit based on my contract rates, we get paid for the work that you performed up to that point and nothing more. Whereas on a damages claim, you could say, well, I want to be paid as if I proceeded under the contract and got to that point. I would have got all that, but I also get the balance of the profit on the balance of the works that I didn't perform. So you won't get that profit on a restitution in quantum merit because it's purely restitutionary remedy.
Indeed.
So you might be better off sticking to contract and
You'd be suing damages, I think, in that.
I think you would.
Yeah, that's it.
Yeah. So that's right. They're the questions that have to be carefully looked at now when you're thinking about terminating, accepting repudiation and terminating.
Are there any other questions? I think we can all be most grateful to the High Court judges for leaving this a still fertile area for debating and argument. And I think we can also thank Lucas and Derek for